It's been 8 years since Leslie Kean's 2017 New York Times story released footage of U.S. Navy pilots chasing UAP. It took the U.S. Congress 6 years to schedule hearings on the UAP topic during 2023 and 2024. During 2025, we've learned more about the phenomenon from independent whistleblowers and journalists than we've ever learned from the U.S. government over the past 78 years. Why has UAP disclosure been so painfully slow? Until recently, UAP whistleblowers perceived a lack of benefits for coming forward, as well as a lack of protections. Many of these would-be whistleblowers have not received any legal advice. Attorney Danny Sheehan is an admirable leader in the advocacy effort for UAP disclosure. However, Danny Sheehan is not a False Claims Act whistleblower attorney. The False Claims Act, or FCA, is a federal law that was enacted in 1863. The False Claims Act was created to prosecute fraud committed by defense contractors against the United States government during the Civil War. In recent years, the False Claims Act has proven to be a critical tool for helping the Department of Justice recover tens of billions of dollars from government contractors, including Lockheed Martin, Northrop Grumman, Raytheon, SAIC, and Booz Allen Hamilton. The FCA's qui tam provision allows private individuals, called relators, to file lawsuits on behalf of the federal government. Qui tam FCA lawsuits are filed against government contractors that knowingly submit false claims for payment. Under the requirements of the FCA, the federal government has paid whistleblowers multi-million-dollar rewards. The FCA also includes federal legal protections against whistleblower retaliation. Today we'll discuss the role of the False Claims Act in UAP disclosure. We'll share recent examples of successful qui tam whistleblower lawsuits against government defense contractors, including multiple settlements with Lockheed Martin, Northrop Grumman, Raytheon, SAIC, and Booz Allen Hamilton. What is the False Claims Act? The FCA is a federal legal statute that imposes liability on individuals or entities that knowingly submit false claims for payment to the government, use false records in relation to a false claim, or conspire to commit such acts. In the context of a defense contractor, fraud might involve billing for work not performed, inflating costs, or misrepresenting the scope of work. For example, if a contractor bills the government for $100 million for activities outside the contract's scope, this would constitute a false claim under the FCA. The federal FCA statute allows the government to recover trebled damages, 3 times the amount of the fraud, plus penalties. As of July of 2025, these additive penalties range from $14,308 to $28,619 per false claim. If a contractor submits hundreds or thousands of false claims, the penalties can really add up, in addition to tripled damages on the applicable contract amount. The qui tam provision of the FCA, derived from the Latin phrase meaning "he who sues for the king as well as himself," empowers whistleblowers to act as private prosecutors, filing lawsuits on behalf of the government. This provision is particularly relevant for defense contractors' workers, including both employees and 1099 contractors with insider knowledge of fraudulent practices. There are several steps to file a qui tam whistleblower claim under the False Claims Act. Step 1. Identify and document the fraud. The first step is for a whistleblower to identify specific instances of fraud. There are several common types of defense contractor fraud. Cross-charging involves shifting costs from one government contract to another. Billing for unauthorized work involves charging for activities outside the contract scope. Defective pricing involves failing to disclose accurate cost or pricing data during contract negotiations, as seen in the 2025 Lockheed Martin case, where the company settled with the Department of Justice to pay $29.74 million to resolve FCA allegations. The whistleblower must gather substantial evidence, such as invoices, contracts, or purchase orders showing discrepancies, emails, internal memos, or presentations indicating knowledge of the fraud, and/or financial records demonstrating unauthorized expenditures. In FCA cases, it is common for the relator, or whistleblower, to be someone with direct, first-hand knowledge of fraud and access to evidentiary documentation. In real FCA cases, the whistleblowers are commonly the chief financial officer, a finance manager, a compliance officer, a consultant, former dismissed employees, or others with direct first-hand knowledge of fraud. Step 2. Consult with an experienced False Claims Act whistleblower attorney. Filing a key TAM claim is complex and requires legal expertise. The whistleblower should consult an attorney specializing in FCA litigation to discuss several key issues. There are two types of False Claims Act attorneys. There are whistleblower attorneys who represent key TAM relators. There are also False Claims Act defense attorneys, sometimes referred to as white-collar defense attorneys. First, an FCA whistleblower attorney must assess the strength of the evidence and the credibility of the whistleblower. FCA whistleblower attorneys commonly work on a contingency basis. Legal fees for FCA whistleblower attorneys, which may be over $1,000 per hour, will accrue millions of dollars against the settlement or judgment during the litigation process. If the FCA attorneys do not win or settle the case, the FCA attorneys will not get paid. FCA attorneys will think long and hard about the strength of the evidence at hand before taking a whistleblower's case. Second, an FCA whistleblower attorney will ensure compliance with FCA procedural requirements. One such requirement is the first-to-file rule, which bars subsequent lawsuits based on the same facts. You want to be the first whistleblower to report government contractor fraud. If you are the second whistleblower reporting the same fraud and you are not working with the first whistleblower on the same lawsuit, you may get nothing. Third, an FCA whistleblower attorney will ensure to protect the whistleblower's identity and rights during the process. Under the federal FCA statute, whistleblowers are entitled to injunctive relief, reinstatement, and/or damages if they are retaliated against for being a whistleblower. In the private sector, while some whistleblowers are terminated, it is not unheard of for a whistleblower to keep their job during a multi-year case. Additionally, FCA cases are sealed confidential. Step 3. File a complaint under seal. The whistleblower, through their attorney, files a complaint in federal district court. The complaint must be filed under seal, meaning it remains confidential to allow the Department of Justice to investigate without alerting the defendant. FCA complaints include several elements. The whistleblower's complaint is a detailed description of the fraudulent conduct. The complaint contains a long list of the plaintiff's claims. The whistleblower provides evidence supporting the allegations. This evidence is commonly in the form of documentation, including financial records, emails, slide presentations, and photographs. The whistleblower and their attorneys will provide an explanation of how the fraud breaks the law and affects government funds. The fraud may trigger the False Claims Act directly through outright fraudulent misuse of funds. The fraud may also trigger the False Claims Act indirectly. If a defense contractor breaks a law other than the False Claims Act or violates a term of the defense contract, this activity may trigger the False Claims Act indirectly by triggering a breach of the defense contract. For example, indirect triggers of the False Claims Act may include falsifying technical results, falsifying quality performance standards, not adhering to regulatory requirements, or not implementing mandatory cybersecurity standards. Any breach of a defense contract's terms is a basis for triggering a False Claims Act complaint and putting the entire contract's value in question as a fraudulent dollar amount subject to triple damage value plus penalties per each violation. Step 4. Government investigation. Once filed, the complaint is served on the government. The government has 60 days to investigate, though extensions are common. After the Department of Justice reviews the complaint, evidence, and completes its own initial investigation, the case may be affected in several ways. First, the Department of Justice may intervene in the case. When the DOJ intervenes in a whistleblower case, the DOJ takes over the case and leads the prosecution. The DOJ has 93 U.S. attorneys nationwide. The DOJ allocates its resources to cases in which it has high confidence it will recover funds and be successful. Alternatively, the DOJ may decline to intervene in a whistleblower's case. This does not necessarily mean the case does not have merit. The DOJ may simply not have the resources for the case. Even if the DOJ does not intervene, it will still allow the whistleblower and their attorneys to proceed independently if they choose. Lastly, the DOJ may move to dismiss the case if the case lacks merit, is frivolous, or simply represents a nuisance case seeking to shake down the defendant for money. Step 5. Litigation or settlement. If the government intervenes, it typically leads the litigation, leveraging its investigative resources to pursue the case. In False Claims Act whistleblower cases, the DOJ can mobilize the FBI, Defense Criminal Investigative Service, the Naval Criminal Investigative Service, Defense Contract Audit Agency, the DoD's Joint Program Office, and offices of the Inspector General in any department of the federal government. If the government declines to intervene, the whistleblower can continue the lawsuit, though this is more challenging. FCA cases take a long time. FCA whistleblower attorneys and their clients should discuss in advance what they will do if the government declines to intervene. Whether the DOJ intervenes or not, an FCA case may result in two categorical outcomes. The first result is a settlement wherein the defendant agrees to pay damages and penalties, but likely admits no wrongdoing. The second outcome is a trial where a court awards triple damages plus penalties if the defendant is found liable. Step 6. Resolution and recovery. If the case is successful, the government recovers triple damages plus penalties. For example, if False Claims Act fraud involves $100 million in improper billing, the recovery could be $300 million, triple or treble damages, plus additional penalties. Since 1986, the FCA has recovered over $78 billion, with key TAM actions accounting for a significant portion. There are major monetary awards for whistleblowers with successful recoveries under the Federal False Claims Act statute. Under the Federal False Claims Act, if the key TAM FCA action succeeds, the whistleblower is entitled to 15% to 30% of the total recovery by law. The whistleblower's award percentage is determined by the court based on several factors. According to Section D of the Federal FCA statute, if the government intervenes in the case, the whistleblower shall receive 15 to 25% of the proceeds of the action or settlement. If the government does not intervene in the case, the whistleblower is entitled to receive 25 to 30% of the recovered proceeds. Within these ranges, the court will consider the significance of the whistleblower's information, the extent of their contribution to the case, the risk undertaken by the whistleblower, and compliance with FCA procedural requirements. Hypothetically, let us assume a defense contractor is spending $100 million on unauthorized activities. If the government recovers $300 million under triple damages, the whistleblower's award could range from $45 million at the 15% minimum rate up to $90 million at the maximum 30% rate. As you will hear during real case examples momentarily, these are not unprecedented awards for whistleblowers. Protections against retaliation. Under Section H of the Federal False Claims Act statute, whistleblowers are entitled to relief from retaliation, such as termination, demotion, or harassment, for reporting fraud. If retaliation occurs, the whistleblower can file a separate claim for reinstatement to their former position, double back pay for lost wages with interest, and/or compensation for special damages, including litigation costs and attorney's fees. Recent developments and risks. The FCA remains a robust tool with 979 qui tam lawsuits filed in fiscal year 2024, the highest in a single year. It is worth mentioning that a 2024 Florida District Court ruling declared the qui tam provision unconstitutional. This ruling only creates binding precedent in the Middle District of Florida for certain specific types of qui tam, false claim, whistleblower cases when the government declines to intervene in cases in this district. At the current time, this ruling is not binding precedent outside the Middle District of Florida. This ruling has no impact on the federal statute. Most major defense contractors are incorporated in Virginia, Maryland, or Delaware. Would-be whistleblowers and their attorneys should be cognizant to avoid choice of law and choice of venue provisions, placing their cases in the Middle District of Florida. At least 15 different multi-million-dollar False Claims Act cases have been settled by major defense contractors during the past 22 years. These 15 cases resulted in over $1.3 billion in total settlements. The defense contractors involved in these cases include Lockheed Martin, Northrop Grumman, SAIC, Raytheon, and Booz Allen Hamilton. The total liability, if damages were trebled in court, would have likely been at least 3 times this amount, if not more. Among these 15 cases, several are worth mentioning. In February 2025, Lockheed Martin Corporation settled FCA allegations for $29.74 million related to defective pricing on F-35 contracts. The company allegedly failed to disclose accurate cost data, violating the Truth in Negotiations Act. Under the federal statute, the whistleblower's award in this case may not be less than $4.4 million. This represents the minimum whistleblower award at 15% of the total recovery. During 2023, Booz Allen Hamilton agreed to pay the government over $377 million to resolve allegations that it violated the False Claims Act by improperly billing costs to its government contracts over a 10-year period. The whistleblower, former Booz Allen employee Sarah Feinberg, was awarded $69.8 million for her role in pursuing the case. In another interesting FCA whistleblower case, Northrop Grumman settled with the DOJ in 2009 for $325 million. Northrop Grumman agreed to settle the matter relating to alleged faulty transistor equipment that its predecessor, TRW, sold to the U.S. government for use in NRO satellites. The whistleblower in this case was scientist Robert Farrow, Ph.D. Dr. Farrow alleged that he tested and identified the faulty transistors as a contractor for TRW through his employer, the Aerospace Corporation. The whistleblower alleged that there was a coordinated cover-up to conceal his test results and report of the faulty transistors, including the use of his non-disclosure agreement. Dr. Farrow received $48.75 million as his whistleblower share of the recovery under the qui tam provision of the False Claims Act. For this Northrop Grumman case, the Department of Justice constructed 3 high-tech secure facilities called Sensitive Compartmented Information Facilities, or SCIFs. Many of the issues of the case could only be discussed in these secure SCIF facilities. This case proves that neither top-secret defense security classifications nor non-disclosure agreements of government contractors can deter the Department of Justice from investigating and prosecuting fraud reported by whistleblowers under the False Claims Act. Who cannot be a whistleblower under the False Claims Act? The qui tam provision of the False Claims Act is intended to target whistleblowers who are private citizens and do work for government contractors. The False Claims Act specifically excludes members of the armed forces. Most government employees are also excluded from being whistleblowers under the False Claims Act if they obtain the information about the fraud in the course of their official duties. Apart from the False Claims Act, there are other federal laws intended to protect whistleblowers inside the federal government. The Intelligence Authorization Act for fiscal year 2014 amended the National Security Act to provide statutory protections for government employees who make lawful disclosures of fraud, waste, or abuse. PPD 19 is a directive signed by President Barack Obama on October 10, 2012, titled Protecting Whistleblowers with Access to Classified Information. Its purpose is to ensure that employees in the intelligence community and those with access to classified information can report instances of waste, fraud, abuse, gross mismanagement, violations of law, or substantial dangers to public health or safety. PPD 19 prohibits retaliation against intelligence employees for such protected disclosures. Conclusion. Private citizens doing work for government defense contractors who discover fraud can use the FCA's key TAM provision to file whistleblower claims. By gathering evidence, consulting an attorney, and filing a sealed complaint, the whistleblower can initiate a process that may lead to significant government recovery, as well as substantial awards for whistleblowers. The 3 defense contract whistleblowers we identified here were awarded from $4 million up to nearly $70 million. This is a substantial benefit for whistleblowers. The FCA's protections against retaliation also ensure whistleblowers have rights to injunctive relief and damages. Despite the recent legal challenge to the False Claims Act in the Middle District of Florida, the FCA remains a vital tool for ensuring accountability in government contracting and DOJ enforcement efforts. Whistleblowers can find False Claims Act whistleblower attorneys and law firms online. Several key TAM whistleblower attorneys and law firms have won large settlements against U.S. defense contractors over the past several decades.